Good morning, everybody. You all hear me?
Good morning. Yes, sir.
Yes.
Okay, great. We're gonna get started up here in just a minute on round two. And I guess I'll wait till it's officially, oh, here we go. It's 10 o'clock now. So Fifth District Court of Appeal is in session now with oral argument on the case of Lamb versus Hill, case number 22-388. We had oral argument previously. It was the court's understanding that we would hear the two cases traveling together as one oral argument. There was a statement made by Ms. Pohl during the argument at hers that when we got your motion in, led us to understand that y'all thought there would be two separate arguments. In the future, I said there was no doubt in our minds, we only intended one argument. In the future, we would expect y'all to plan on having one argument, whether the cases are consolidated or traveling together. If you have any doubt, please check ahead of time. Our in-person argument calendars do list different cases at 9 o'clock where we would have two different arguments. Where we're having Zoom arguments, it's hard and fast. 9 o'clock, when 9 o'clock's over, we have a 10 o'clock and it starts at 10 o'clock. So it's a little different when we're doing these Zoom oral arguments than regular, but be that as it may, we thought the best thing to do would be to go ahead, since both of y'all had manifested at one time or another. You thought there would be two. We'll ask you to not feel obligated to take your full 20 minutes. Since we've heard the basic arguments, you may have something different for the individual defendants than perhaps for the association or supposed to be association corporation. But with that in mind, we'll keep it at 5 minutes. Again, I'm obviously Judge Edwards, and I'm joined by Judge Wallace and Judge McIver. And if you haven't already done so, please put your telephones and everything on silent so that we won't add that to the list of fun we already had. So with that, counsel for appellant, you may proceed, and you'll have 5 minutes for rebuttal unless you need something else.
May it please the court. My name's Patrick Howell, and I'm here today representing Helmut Lamb, Julie Lamb, Mark Sapper, and Terry Abergele. I would like to reserve 5 minutes for rebuttal. After 15 years, the Hills seek to pierce the corporate veil and hold their neighbors personally liable for actions taken as directors and members of a corporation, the HOA. Pending a ruling of this panel and the companion case, traveling with this case, that indeed there is a valid corporate entity, the business judgment rule protects the directors from liability, especially for simple negligence as pled by the Hills. Further, Ms. Abergele, who never served on the board, owed no duty to the Hills whatsoever. As to these individuals, the Hills have failed to produce any evidence of fraud, self-dealing, criminal activity, but instead have, as I said before, pled simple negligence. There's two types of mismanagement that are alleged here. One is for the common areas, and one is for financial reporting and the operation of the HOA. These were all corrected in 2016 when the parties got together and realized that they were not operating the association pursuant to Chapter 720. So 2 years prior to the lawsuit being filed by the Hills, that's when the financial reporting began by the association. They began to properly notice the meetings, and they began to do all the things that are required of an HOA through legal counsel. Here's a timeline of the mismanagement. All of these activities occurred more than 4 years prior to the filing of the Hills lawsuit. In 1999, that's when Mark Sapper and Terry Abergele moved into their unit. 2003, that's when the Hills purchased their unit. At that time, they were provided a copy of the declaration by their own admission. Vicki Hill read the declaration immediately, 2003. In 2005, the Hills filed an insurance claim for damage to the common areas after discovering that there was no policy that was covering the common areas. So they knew since 2005 that to be the case. In 2008, the Hills discovered that the pool leaked, or at least they thought it leaked. They brought it to everyone's attention. In 2009, they brought it to everyone's attention that there was a depression in the common areas. They stated that it was noticed 5 to 6 years after they purchased their unit, which was in 2003. In 2010, Vicky Hill again brought up the pool leak in a letter, an email. 2010 drinking water concerns were brought up by the Hills as well in that same letter, as well as irrigation system concerns, and the yard depression was again brought up. Again, in 2018, June 25th of 2018, that's when the Hills filed their lawsuit. Some 8 to 12 years after noticing these alleged negligent activities. Thus, the statute of limitation bars the Hills claims, and the trial court erred when there was absolutely no analysis or addressing of the individual's affirmative defenses related to statute of limitations.
Counsel, let me ask you a little bit about the pool. I think there was a meeting at some point, perhaps in 2016, when the three parties agreed that they would hire Brevard Pools to come out, see if they could find the leak and fix the leak. And that was an agreement from what I saw, at least from some of the testimony. And instead of doing that, Mr. Saffer, if I understand, canceled the Brevard Pools and started cutting holes and trying to fix it himself. Is that correct?
That is correct. And what was
well, why to the extent that happened at that time frame, was that within the 4 years of suit being filed?
I'm not sure about the timing of that, honestly. What I can tell you is that the pool issue and all of these common area issues and operational issues were issues that were discovered, many years ago by the Hills and discussed.
But they had an agreement. They had an agreement at that time. I mean, a condominium may have a problem when they have an agreement to fix it, and somebody says, "No, I'm going to do it myself." He undertakes to do that, and then doesn't accomplish it, regardless of piercing the corporate veil. I mean, he's undertaken a duty and hasn't discharged it. On top of which, he's done it in violation of the agreement that the group came to, whether they were 3 individuals or as a homeowners association. Tell me exactly how that's okay.
Well, that doesn't rise to the level of negligence. There's no duty. If the Hills are to be believed, these common areas were never conveyed, and this swimming pool is not something they own. So I don't know how a duty can attach. The second part is that let's look at the damages, which is an essential element to a negligence cause of action. They weren't harmed by the pool. Their damages are that they brought in Mr. Robinson to look at the pool, and he had no comments on whether the pool was out of code or was somehow not maintained or was improperly maintained or anything like that. So their damages are hiring someone to look at the swimming pool, to look at these different areas, and then he comes along and says there's no code violation, there's no issues. So I get what you're saying, and I understand that, but there's just simply no damages. The same thing with Sandy Towns. Sandy Towns was retained by the Hills to look at the finances, to look at whether or not the association was operating properly. And what she found was that there was no finding of any sort of wrongdoing. She said that it was sloppy before 2016. We agree with that. It was sloppy before 2016. And when it was discovered that the association wasn't being operated as it should be, That's when everything was tightened up. They started doing year-end financials as are required by Chapter 720. They made the records available to the Hills to review. Their attorney spent 5 days looking over the documents that were provided by the association to copy. Now, speaking of sloppiness, that law firm did a sloppy job of copying records, and it was very hit or miss as to the things that were copied and then passed on to Ms. Towns. And so Ms. Towns looked at it and said, I can't line up some of these checks with everything. We then deposed her, and I went through and I said, you weren't provided these documents. We went through every single one of those entries and were able to match that up. And she said, yeah, no wrongdoing here. She's also not a Florida.
Mr. Howe?
Yes, yes, sir.
You made the statement that the homeowners association, until it began operating properly, is it your position now that the homeowners association even now is operating properly?
The homeowners association is operating properly since 2016. So 2 years prior to the lawsuit being filed. That's the testimony of, I believe that's uncontroverted. There were meetings. Please keep in mind that.
So a question I have then, I believe, has the homeowners association ever filed paperwork that is consistent with the required name that was required in the declarations when it was first created?
Yes, Your Honor. In 2018, that occurred. So what everyone agreed that needed to be addressed. The Hills believed that the entire corporation needed to be wound down and then started over. The advice that was received from the association's legal counsel was that no, it doesn't need to be done. That does not need to be done. That's more expensive, and that would be a waste of resources of the HOA. So they said a name change would suffice. I believe that is conceded by everyone here, including the Hills, that there were choices that were provided to the HOA by their legal counsel. They chose to go with the option that the Hills didn't agree with, but there was a proper meeting and there was a vote to move forward with the name change. The other thing to keep in mind is with the operation of the association after 2016, the Hills ran for the board. They ran for the board of directors. Their attorneys attend and submitted a proxy on their behalf and actually submitted their names for the board of directors. So it's very disingenuous for the Hills to come along now and say, there was never an association. We never believed that. We never understood that to be the case. We don't know what's going on. They attended meetings and they attended annual meetings and ran for the board of directors. So it's a bit disingenuous for them to argue now that they don't know what's going on or didn't know what was going on. As to the individual defendants, if you look at the final judgment, as to Julie Lamb, let's take as a for instance, the trial court said that all the parties appointed her as the liaison between the other parties. How in the world can a person that is appointed as a liaison have a duty to the Hills and breach that duty? She was the go-between for those folks. So that statement in the final judgment doesn't make any sense. The final judgment also on page 9 as to Julie Lamb says that she engaged in post-litigation activities, collection of dues, recording bylaws, the declaration and the rules, and was involved in the name change. There's no finding of fact whatsoever as to alleged mismanagement by Julie Lamb. How can there be a breach? As to Terry Abergili, it's even worse. The final judgment on page 9, it mentions her once, that she assisted with the finances and the management of the common areas. There's not one finding of fact that Terry's actions were unreasonable or that she somehow breached a duty to the Hills. It's just nowhere in the final judgment at all. As to Helmut Lamb, it says that the Hills law firm had to be hired to discover the failure of Mr. Lamb to deed over the common areas. That's the damages against Mr. Hill, part of the $75,000. This is a matter of public record. That, you know, you don't need to hire a law firm to go into the public records and look to see who owns the common areas. The same with the incorporation issues. Those are all on SunBiz. Anyone can look that up. And Ms. Hill testified that she was familiar with SunBiz. You know, she had her own business that she had incorporated here in Florida, and she knew how to navigate SunBiz. So that's the findings as to Mr. Lamb. Obviously, the other big thing is as to count 4, and the trial court said that Mr. Lamb failed to deed the common areas before trial was before the lawsuit was filed by the Hills. Well, it's undisputed that everyone was talking about the deeding of the property, but everyone also understood that the name change had to happen first. It made no sense to deed the common areas into the name of the corporate entity, with the wrong name. And so everyone agreed, you know, we got to do this first. In fact, the meeting to change the name occurred prior to the lawsuit being filed by the Hills. It was like a week or so beforehand. So they said, step 1, we're going to change the name. Step 2, we're going to have Mr. Lamb deed the common areas. So this allegation that they had to hire a law firm to get this done or file a lawsuit to get this done is just not borne out by the record whatsoever. As to Mr. Saffer, the allegations are that one where in the final judgment it says that Mark Saffer was elected to the board on September 8th, 2017, 1 year before the lawsuit was filed. It also says that Brian Hess, the lawyer for Mr. Saffer, handled that election agenda. Again, how is hiring an attorney to run an association and do all of these things? That's not a breach of your duty. That's actually fulfilling the fiduciary duty that these board members had to the rest of the association members, including the Hills. Final judgment, paragraph 37D, $762.55 in interest income over 3 years. And then the CD no longer appears on the bank records after 2008. So the trial court was looking at supposed bad acts of Mr. Saffer that occurred in 2008. Statute of limitations. I'll reserve the rest for rebuttal. Thank you.
Okay, thank you. Ms. Pohl, when you're ready.
Good morning, and may it please the court, Beverly Pohl from Nelson Mullins, and I'm here on behalf of the Hills. Inevitably, we are having to look back to the case that was argued last week to understand this case. And the argument that the appellants make that they're protected by the business judgment rule makes a presumption that the acting association is fully authorized to be the homeowners association for these 3 units. And if the trial court rejected that, obviously, and if this court should reject that, then the business judgment rule cannot apply. What I mean is, if this court should also reject the concept that the acting association is valid and affirm the lower court. The business judgment rule only applies if the association is engaging in authorized acts, and you look to whether it has statutory or contractual authority. And the whole premise of the Hills position is that it doesn't have that kind of authority, and that the trial court agreed with that. So if we lose on the acting associations count 6 in the other appeal, then we lose on the business judgment rule. But if we win on the argument that the acting association has no legitimacy and no authorization and no power, then these people were in the process for years, voluntarily assumed duties and held themselves out to be the proper officers and directors of an association that had no power. And that's why they can be held individually liable. Because when a person undertakes a duty and then on top of that does it negligently, and there's just not one or two instances of mismanagement here. I think in the final judgment, they're listed A through I, 16 or 17 or 18 particular types. And even if counsel can throw some doubt about one or two of those, that doesn't vitiate the fact that this was simply not handled right from the beginning. One of the comments that was made by counsel's argument is if the Hills are to be believed regarding whether or not the acting association is valid. This isn't about believing the Hills. This is about whether the trial judge was correct in making that legal conclusion. So I don't want to view it as something the Hills are saying. The trial judge made that finding. With regard to the damages against each of the individuals, the final judgment sets it out pretty clearly, as he said, on page 9 of the final judgment. And each of them took steps that made it look like they had authority and power that the trial judge said they didn't have. And the real bone of contention, I think, is Teresa Aberge, because she never was an officer of the acting association, but she had the power of the purse, and that is a very important power. She signed checks on behalf of I'm calling it the acting association, just to be consistent and clear with my prior argument. But when she has the power to sign checks, I don't know how anyone could say that she wasn't holding herself out as someone with authority. And there are two places you could look to see that. Plaintiff's Exhibit 47 at record 6266 is a check that she signed, and it's a check from the account of Lamb Townhouse Owners Association from 2012. That was after the acting association was formed. And if you look back even further, and I know that there's a statute of limitations argument, but this is in the record, that she not only signed checks years ago, but the association that didn't really exist had a bank account that had her name on it: Mark Saffer, Teresa Aberge, and Lamb Townhouse Association. And to me, that's enough personal involvement to hold her personally responsible. That's plaintiff's exhibit.
Counsel, the check you're talking about, if I'm looking at record 6266, it looks like $100 payment to a lawn company. Is that right?
That's right.
Regardless of the association setup, I mean, was that for lawn work done at the premises?
I don't know, but what business does she have signing a check on behalf of the association when there was no association? That just doesn't make any sense whatsoever. And like I said, if there was a valid association, business judgment rule is going to prevail for them. But if, as the trial court said, that association had no power or authority to conduct business on behalf of the common areas or the homeowners, then she is acting outside the bounds of the association's authority and her own authority in doing that. So
Ms. Paul, I have a question. I think this is a question that I had actually last week as well. But I believe the evidence was that your clients provided the insurance for the common areas for the community. Is that correct?
I believe that they did. I believe that they did at some point.
Okay, and it was for the common areas. So I guess my question is why were they individually providing the insurance?
I can only presume that they were concerned about the fact that there didn't seem to be any insurance otherwise. That's the only thing I can assume.
Was there any testimony or evidence that the HOA was incapable of providing the insurance coverage?
There wasn't an HOA. That's the whole point we have here. There was no valid HOA.
I understand no valid HOA based upon the required association that was in the originating documents, but I'm talking about the name that they were operating under, albeit an improper name. They were not able to secure insurance for the common areas. Is that
I
correct?
believe there's an email in the record from Julie Lamb saying, because of the problem with the name, we can't get insurance and we can't put up a fence or something. The problem with the name, although I don't think that's the biggest problem in the case, did have some effect on the ability to get insurance. Yes.
Thank you.
There were certain overstatements made in the appellant's argument this morning, and one is that it was uncontroverted that the acting association was operating properly. And that certainly doesn't fairly represent the Hills position, because their position is that nothing it did was authorized or proper. Again, it was represented that Mr. Hess advised his clients to do a name change, and that would be legally sufficient. And I understand that he wrote a letter and he said, here's 3 things you can do. But if there was really an advice of counsel defense here, Mr. Hess would have testified. You don't just look at a letter and determine that that's sufficient advice of counsel. There's no real discussion of that. He's just said, here's 3 things you can do. And he may have been right or he may have been wrong, but this was not an advice of counsel type situation. And of course, the trial judge rejected it. The only other thing I wanted to say about the individuals was that the use of the term liaison or voluntary doesn't excuse them from liability. If anything, it supports liability, because, as I said, if somebody voluntarily takes on a duty, then they have to do it well. And its record is replete with things that were not done well. And you can look back a long way, or you can look back 4 years, but it is really undisputed that there is a long list of things that weren't done right. And that was first discovered when in 2016, it started really in 2015, when the Hills kept asking for information. Give us the official records that Chapter 720 requires an association to keep. They were never given such records because they were never kept. There was no association, there was no bylaws, there was no rules, there was no finance records, there was nothing. And that's what caused them to hire counsel, and that's what caused them to make a full investigation. They hired an engineer to see if all of this construction on the property had been properly permitted. No permits were ever produced. So maybe it was actually built okay, but it wasn't built in compliance with the law. Things just weren't done right. And the accountant that they hired, she and the defendant's accountant agreed that the accounting records were poor. I think that was the word they both used. And to suggest that everything was done according to Hoyle, it is just not a fair representation of the record. Maybe they did try and fix it later after the Hills brought to their attention in 2016, but you can't fix it if it wasn't the authorized association to begin with. And that takes me back to the case that I think is very important, the Stewart case, the 100-year-old case that was cited by the association, that says if you change the name, it's still the same entity. So by changing the name of the acting association to the name that was stated in the declaration, it didn't change the quality of it. It just changed the name. So any of the failings of that corporation that had taken place before were still going to be there. And no, we haven't identified anything that could result in liability, but it's absolutely, as a matter of law, true that without a valid association, the Hills and the other homeowners would share liability for things that arose during that period when there was no valid association. So that pretty much takes care of count one. There were mismanagement activities. They voluntarily undertook to do these things. They didn't do them right. And the amount of damages that were awarded are really moderate. And they were absolutely necessary for the Hills to document what they believed to be true and what proved to be true, which was that this wasn't being handled the way it should have been. And with regard to Helmut Lamb, his big responsibility at the beginning of this case, not this case, but at the beginning when he decided to have these 3 units and have the declaration and have people live there and have an association, his was to form the incorporated association, named exactly what it said, and then to convey the property, the common area property, once the first unit was sold. He didn't do that. And he never did that because he conveyed it to the wrong entity in 2018. The Hills didn't agree. They didn't impede that from happening. They didn't think that that was the solution. As a matter of law, that wasn't the solution. So the trial court found that Helmut Lamb breached the duty that he had, and it still hasn't happened. And even though this final judgment announced that it hasn't happened properly, it still hasn't happened. So we think as pertains to count 1 and count 4, the trial judge's findings and legal conclusions are amply supported by the record and should be affirmed.
All right, thank you, Mr. Howell.
Yes, thank you for the opportunity to rebut. One of the items of the Hills damages that I didn't get a chance to go over, and it was mentioned by Ms. Pohl, are the legal fees. So the Hills hired lawyers to do basically 2 things: investigate the situation with the corporate status. That was done, and then also the issue of the failure to deed the common areas. So those are the 2 things that the trial court said they needed to hire law firms and spend $55,000 investigating this. Again, both of these things are matters of public record. They did not need to hire a law firm to find out that the common areas weren't deeded, or that the corporation name was different than what was referenced in the declaration. That just wasn't needed. And then secondly, the trial court does not explain how we get away from the rule, which is that legal fees as a matter of law are not damages in Florida at all. So that's something that is another failing of the final judgment. The trial court just did not explain why this $55,000 somehow gets around that general rule. The other thing that was said, is there is no HOA, and this is the drumbeat by the Hills, and the question comes this way: if there's no HOA, then where is the duty to deed the common areas, to produce records under Chapter 720, not to commingle funds, generally abide by Chapter 720 meetings, things like that, procure common area insurance, refrain from using the common areas to store items, install fencing or fix the pulley? It doesn't make any sense that there's a duty if there is no HOA. And then if there isn't an HOA, that's where we've got the business judgment. The other part that's a head scratcher is if the common areas weren't conveyed, and that is the finding of the trial court, and also the HOA doesn't exist, also the finding of the trial court, what interest do the Hills have in the common areas at all? If the answer to that question is none, then how do they have standing at all to say that anything was mismanaged? It's not their swimming pool. It's not their gazebo or any of these different other areas. So that was the other part of the final judgment that really doesn't make sense. As to Terry Abergili, it was mentioned that she had the power of the purse. That is simply not true. What the testimony was by Mr. Saffer and by Ms. Abergili was that she signed every single check under the direction of Mark Sapper, the president of the association. So yes, she was on the account. Mr. Sapper travels for work. He's often gone, and to get the landscapers paid, to get the folks paid that clean the water system, to get these basic services done, electric bills paid. She was a signer on the account, but she never did so, and the testimony is very clear, without Mark Sapper's direction. Unrebutted was the issue as to Miss Lamb. She was appointed the liaison by all the parties, including the Hills. How in the world can she have a duty when she is a liaison of the Hills? And again, back to just looking at the final judgment, there's no findings of fact as to anything that she did wrong. I appreciate your time. The final judgment of the trial court should be reversed. Thank you.
All right, thank you. We will be in recess, and to quote the legal scholar Porky Pig, that's all, folks. See y'all later. Thank you.